It just makes me a bit uptight, because the question question really is of course of training. I'll come to that. The question is, why should the United States care about what happens in Bhopal? And the answer is in one simple word: it doesn't. It simply doesn't. Therefore, extradition of Warren Anderson was never possible. I myself found there was a question whether with a treaty of extradition with US, whether there was a limitation period within which we must file extradition proceedings. I myself found a treaty between then colonial India, the UK, and Canada, and USA, and from that we were able to find, I'm not recalling it entirely, but there was a colonial treaty of extradition that we found useful, and we filed an extradition motion. What happened? Nothing. So it's not a question of training judges and prosecutors. It's a question of clearly it's a crime, it's a felony. It was murder, negligence, rash or negligent act, all the criminal charges that we filed before the criminal court in Bhopal. There was no ambiguity. This was a political crime. You do not extradite people for political crime, but you have to extradite them for ordinary crimes. And it's a clearly an everyday crime. But the US simply would not extradite him. So what did we think? I played with the idea that we must change the law in cases of this kind. How do we change the law? We should find a way of extraditing the whole corporation, not just one man, but all the key officials, the entire network of decision makers. That is, transferring them to stand trial. Of course, if you can't transfer one man, extradite one person, you can't obviously extradite the whole lot. But there is an idea here that is new, that you renovate the idea, the notion of extradition in case of corporations to stand prosecution in countries that they've harmed. It didn't fly. It was not in the short term. In the long term, I still press on with it. The United States made it impossible for inclusion of companies and corporations as liable for crimes against humanity. This was the Rome Treaty establishing the International Criminal Court. A lot of us had proposed that just as states can commit crimes against humanity, so can corporations. And in fact, there are two decisions in Nuremberg trial holding two German corporations guilty of crimes against humanity. So there's a precedent. United States of America made sure that that provision was not included. And after all, after that happened, it did not ratify the treaty either. So why should the United States care? Well, what can you do by training your prosecutors and judges against the lawlessness of a solitary superpower? Nothing. That's one dimension. But second, I recognize the importance of programs of creative learning by judges, prosecutors, lawyers, bureaucrats, techno-scientists, policymakers. This training, however, should be specifically geared to responsibility and human rights. Not geared to enhance their competence to violate both. Sometimes training programs increase the power to violate human rights and responsibility. And there's an addition, a surplus we don't need anywhere. There's already enough power there. So it has to be done very imaginatively.
Just to go back